Alrighty. I want to thank everyone for being here today. My name is Buchilo. Welcome. And as you're joining us, please, you know what to do. Like, subscribe, comment on this broadcast. Today is another beautiful day, and we are excited to be in your presence today to talk about the recent court victory of Mazi Nnamdi. All right. You must understand that it has been a long road coming. It has been a long road coming. To get to this point of justice and victory, it did not just start now. It started a long time ago. All right. But today we are going to be going through several things that have happened in the past. Most recent, issues that have come up from his victory. And also we're going to talk about what the next steps will be. All right. If you are just joining us, this is the Leadership Standard, and I'm your host, Buchi Law. So without further Without further ado, I want to welcome everyone. Please get your water, whatever drinks you're having, and let's talk. Let's have a conversation. And also, please post your comments down on the comment section below, just in case we need to have any conversation. I can read your comments too. So, the courts have discharged and acquitted Mazi Nnamdi. Don't listen to any lies anyone tells you that, oh, he was just discharged. They've discharged and acquitted him, all right? And if you understand how law works, you understand that what that means is that they have freed him of all the charges that he has had ever since all this trial began. So if somebody is going to take you to court, all right, if the state government is going to take you to court, they should have everything ready. They should have all their complaints ready, all their pleading forms ready, everything ready to file the case in court. They should have all their witnesses ready. They should have all their evidence ready, all the exhibits ready. You cannot keep on a trial forever. There is no way in the world where you keep continuously trying somebody ad infinitum. There has to be an end to a persecution. There has to even be an end to prosecution. You cannot continue trying somebody over and over and over again for crimes that you claim the person committed, and you have no substantial basis to prove your claim. It's not enough that you say someone committed a crime. You have to have the evidence ready to prove your claim when it is time for you to do so. If you notice the pattern that the Nigerian government has had, they will keep constantly changing their complaints, changing their, the forms that they want to use to prosecute Mazi Nnamdi Kanu. They keep changing it constantly. And one must ask, why do they keep doing this? It's because of the fact that they are not prepared. They were never prepared from the first go. They wanted to do mago to the answer. They wanted to do abracadabra to the answer. But when you're coming to court, this is not a jungle justice where somebody just shouts, yes, he committed a crime, burn him, bring petrol, pour petrol, burn him, light fire. That is not how they do things in a civilized world. If we are going to be regarded as civilized people, then it is by all means that we all act as civilized people. All right? So now the Nigerian government has no case against Mazi Nnamdi Kanu. They never did. They never had any case against him. They only wanted to just keep him in their custody up until, God forbid, they finally get rid of him. But because of the news and how much international news Mazi Nnamdi Kanu's case has been, thankfully, that God in his infinite mercy has found it that his case is an international matter and not just a local matter. That is the reason why the Nigerian government has been treading carefully against his matter. But even as at that, the Nigerian government is still bent on holding him down. They are still bent on not releasing him. That is how far their wickedness is going. They don't want to release this man. They have no desire to release him. They know the damage that he's going to cost them. So now look at what, even after they have said that he has been released and he should be let go, they are still saying his case is not over. They want to exploit all appropriate legal options. What other legal options do they want to exploit? The closest legal option that they can exploit is the option of going to the Supreme Court. But even as at that, even if they want to exploit that option, they still cannot keep Mazi Nnamdi Kanu in prison while they exercise those options. They have to release him. So now the federal government has said that they're going to approach the Supreme Court to challenge the Court of Appeal judgment that squashed the terrorism charge if preferred against the leader of IPOB. So they say they want to go to Supreme Court. Reacting to the judgment, the federal government, through the AGF and Minister of Justice, Mr. Abubakar Malami, contended that Kanu was merely discharged by the appellate court and not acquitted. See how they are fabricating lies. See how they are coming up with new lies and new information, saying that he was not acquitted, but he was only discharged. The statement of the AGF made available to newsmen through his media aide, Umar Gwandu, read, "The Office of the Attorney General of the Federation and Minister of Justice has received the news of the decision of the Court of Appeal concerning the trial of Nnamdi Kanu. For the avoidance of doubt, and by the verdict of the court, Kanu was only discharged and not acquitted." So they are trying to say that he was only discharged of those cases, of those matters that were brought against him, but he wasn't acquitted, meaning he wasn't allowed or free to go. But that is all lies. That is all lies. Consequently, the appropriate legal options before the authorities will be exploited and communicated accordingly to the public. The decision handed down by the Court of Appeal was on a single issue that borders on rendition. Let it be made clear to the general public that other issues that predate rendition, on the basis of which Kanu jumped bail, remain valid issues for judicial determination. The federal government will consider all available options to open to us on a judgment on rendition while pursuing determination of pre-rendition issues. You can see what they're saying. You see how they want to play their own game. They are playing a game that they will not be able to finish. This is how they want to delay Mazi Nnamdi Kanu's matter. They want to keep him in court because they have nothing against him. They have nothing. What other exploitation do they want to exploit? They've exploited this man for so long. They kidnapped him against his will. They put him in jail. They've burnt his house. They killed people in his house. What other legal options do they want to exploit? All the options that they want to exploit has already been exploited. Right now, they're just wasting time. They're just trying to, divert the issues that are on ground. The issue on ground is that they have nothing against this man. They never did have anything against this man, but yet they are still trying to play in the gallery. They're still trying to showcase their foolishness. They're still trying to showcase their inability to understand how the legal system works. They're still trying to play this jungle justice in the court of law. That is what they are doing right now. It is a case of jungle justice in the court of law. A case where these people, they have no idea what they are doing, but rather they want to just keep postponing this matter ad infinitum. For how long would they? What other options do they want to exploit? The Court of Appeal's judgment and decision is clear. That's why I believe that at this point in time, it is the Court of Appeal that will have to make an order, a sitting order, saying that if the Nigerian government doesn't release him, then they're going to hold Malami in contempt of court. They're going to hold his office in contempt of court. And they should also institute fresh charges against Malami and against his office. Because Malami and his people, they are the ones that are violating the constitution of the Nigerian government. They are the ones that are violating the laws, the international laws that Nigeria is a signatory to. So they should be held responsible. They should also be held in contempt of court. So this is not what anybody will now come and tell you that they want to exercise options. What options do you want to exercise that have not been exercised already? How much time does the Nigerian government have? I think that they have to keep going around and around in circles. They can't keep going round and round in circles. They have to be able to open their mouth and make a decision on what they really want out of this case. And I want to read some tweets from Barrister Ifeanyi Ejiofor. This is Barrister Ifeanyi Ejiofor, one of the counsels to Mazi Nnamdi Kanu. And this is what he says about what Malami said. He said, I hope you all can see this and see what I'm saying. This is what Ejiofor says. In the quick reaction of the Attorney General of the Federation to the erudite and unassailable judgment of the Court of Appeal just delivered yesterday on our appeal, he indicated that the federal government is considering the options it has, including proceeding only with the counts that were pending against Mazi Nnamdi Kanu before the bloody invasion of his house on the 14th of September 2017. Now, for the avoidance of doubt, the federal government has no options. It has only one option, namely to appeal against the judgment of the Court of Appeal to the Supreme Court. And the exercise of this latter option shall not constitute a bar to immediate compliance with the order of the Court of Appeal, which directed for an immediate and unconditional release of Mazi Nnamdi Kanu. The order made by the learned justices of the Court of Appeal is sacrosanct and must be obeyed immediately without further ado. Further, the Attorney General of the Federation, in reference to the charge pending against Onyendu before he left Nigeria in 2017, and the indication that the federal government may continue with the charge really shows his total disconnect with the law. With greatest respect to his office, it is to be noted that the remaining 7-count charge that was struck out by the Court of Appeal after it allowed the appeal on the ground that the Federal High Court has no jurisdiction to try Mazi Nnamdi Kanu is the same charge to wit that has been pending against Mazi Nnamdi Kanu at the Federal High Court since 2015. The prosecution has amended their charges 7 times. You must understand that these people have amended their charges about 7 times. How much more can you prove that you are not ready for a case? How can you amend a charge 7 times if not to delay the matter? If not to delay the matter, if not to cause confusion, if not to cause a delay of justice. The Federal High Court struck out 8 counts and retained 7. On appeal, the Court of Appeal struck out the whole charges and held that the lower court had no jurisdiction to try Mazi Nnamdi Kanu. That being so, that charges that has been pending against MNK since 2015 and containing counts of alleged offenses committed by him before he escaped from being killed in Nigeria in 2017 no longer exists. It has been struck out. I want you all to understand that Mazi Nnamdi trial did not just start from when he was kidnapped. His trial started from 2015. 2015 has been the beginning of all his legal troubles since 2015. And it has taken a long time. 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022. This is almost how many years now? 8 years. Well, we're in October of 2022. 8 years, somebody has been in court trying to figure out the decision. And just yesterday, after 8 years of court, how many of you can survive 8 years of court? How many of you can survive 8 years of persecution? How many of you can survive 8 years of harassment? How many of you can survive 8 years of bullying? Even if you don't care about the person, at least think about it. Should a justice system keep pursuing somebody for 8 solid years just to prove a point? Despite Mazi Nnamdi being in jail and in custody, how much difference has that made to the people? How much difference? The lives of people are still suffering. There's still kidnapping. There are still killings. Boko Haram members are being released from prisons, given amnesty. There are still no jobs. People are still in school. People are still at home. Schools are on strike. Has this stopped anything from happening? The answer is no. So for 8 solid years, Mazi Nnamdi case has been a case in court. So back to what Barrister Ifeanyi Ejiofor was saying. There is therefore no existing charge on the basis of which the Federal High Court can proceed and try Onyendu. Accordingly, as it stands today, there is no criminal charge pending against Onyendu Mazi Nnamdi. The declaration by the Court of Appeal that the Federal High Court has no jurisdiction to try Onyendu Mazi Nnamdi because of the illegality of his abduction and extraordinary rendition to Nigeria is an all-pervading instrumentality that effectively bars any indictment of Onyendu Mazi Nnamdi in any court in Nigeria, as his forceful abduction in Kenya and rendition to Nigeria has violated all known international conventions and protocols to which Nigeria is a state party. You must understand that while the Nigerian government is trying to figure out what to do with Mazi Nnamdi, they are constantly violating international laws, local laws as well. They have to make up their decision and make up their mind. What do they want from Mazi Nnamdi? No prosecution against him in Nigeria can ever be undertaken. This is because a course of action cannot arise from a base ground. The Attorney General of the Federation should be appropriately guided in law. I implore him to meticulously read the full judgment of the Court of Appeal, immediately comply with the orders made therein, and possibly consider the most appropriate option of voluntarily resigning for exposing the federal government to this international embarrassment. As you can see, this is an international embarrassment of the highest order. This man wants to violate the Court of Appeal's decision. This man wants to violate the Court of Appeal's decision. That can show you how much they don't care about. They don't care about the judicial system. They don't care about it. All they care about is to punish an innocent man. They tried using Justice Nyako. Of course, Justice Nyako knew that she could not do more than what she did. So she struck out some charges, kept some. And now they went to appellate court, Court of Appeal, struck out all those charges against Mazi Nnamdi. But now these people are still trying to hold him down. You cannot keep a good man down for long. You cannot hold a good man down for long. After a while, the man will rise as a phoenix. He will rise as a phoenix, because this is now no longer prosecution. This is now what they call international embarrassment. But I want to play a video from Mike Ozekame, one of the Nigeria, and also what he thinks can be done in this issue. Let's take a listen. And by the way, this is credited to Channels Television.
Well, what it means in clear parlance is that Nnamdi Kanu was discharged today. That means he's a free man, and he should be allowed to go home tomorrow. By the time we get a certified true copy of the judgment, we serve it on the office of the Attorney General and the DSS to allow Nnamdi Kanu go. Let my people go. That is how it is put in the Bible.
But Chief Ezekume, we've heard from the federal government right now.
Was not allowing that, there was a problem. Yeah.
We just had the update from the federal government saying that it's just, on a single issue bordering on rendition, and they are looking at taking other legal options, afforded to the government.
The single issue bordering on extraordinary rendition after he was brutally captured, tortured in Kenya, blindfolded, and extrajudicially rendered back to Nigeria, is what determined it. We put all the facts before the court. The federal government had no answer to any of the allegations. And in law, when you make a certain factual allegations and they are not denied, they are deemed admitted. So if the federal government wants to pursue trifles against a citizen by appealing against such a well-rendered judgment, I can only wish them good luck. But let me also tell the federal government, if they appeal, I'm going to file a cross appeal against two of the issues which I do not agree with the Court of Appeal. That is the issue of the status of the place of commission of an offense. Section 45 of the Federal High Court Act and decisions of the Supreme Court make it clear that you can only try a person in a place where you disclose the venue of the commission of the crime, the time, the circumstances. But when you say Nnamdi made a broadcast, from where did he make the broadcast? Is it in the spirit world? Is it in the land of the dead? The Court of Appeal, with all respect, appeared to have glossed over that something by saying, oh, it didn't matter since the charge, the counts did not deceive him. That is not the issue. Supreme Court, look, the Lebanese case that was tried, we all watched it, was it last year? They were accused of having catch of farms in Kanu, but they were tried in Abuja. And the Supreme Court quashed the entire judgment because it is the venue of the commission of a crime that you should try the person. And now the Kanu, you say he made a broadcast. You have not told us where he made this broadcast from. The other one, the Court of Appeal also agree with us, where they said he brought in a transmitter at Obulu Suzo in Ihiala local government area of Anambra State, which is outside the jurisdiction of the Federal High Court of Abuja. They also agree with us. But all in all, the issue was jurisdictional. And that is that under the Extradition Act, particularly Section 15, and under international conventions, OAU, United Nations, you cannot extrajudicially render a person by brute force, by force of arms from one country to another. There must be a warrant of arrest, which must accompany a written document to the host country that we want this person back. They did not do that. They just forced him back. And the doctrine of specialty is that even when you bring such a person back, you can only try him for the offense that you are bringing him back for. But they still subjected Nnamdi Kanu to the first initial 5-count charge, which they later amended to 7 counts. Then they later amended again to 15 counts. Let me tell you, the federal government has amended the counts against Nnamdi Kanu 7 whole times. And at the Federal High Court, I was able to get 8 of the 15 counts dismissed. It was the remaining 7 that the lower court held on to that were today dismissed by the Court of Appeal. The whole remaining 7 counts were set aside, and then Nnamdi Kanu was set free, discharged by the Court of Appeal. The Supreme Court has said such a discharge amounts to discharge and acquittal. If they want to appeal against a mere citizen, when I think the federal government should see this as a good reception, as a matter that is good for the whole country, to bring about normalcy, peace to the Southeast, peace to Nigeria, and then you still want to appeal, then my take on it is that it will amount to persecution and no longer prosecution. In any event, why should the federal government, through the DSSS, that arrested this man, they are keeping him, they investigated him, they are prosecuting him, they are Lord and Master, the accuser, the prosecutor, the judge. And that cannot be a fair trial or a fair hearing. So what the Court of Appeal did today is what the federal government should have quickly done even before the Court of Appeal intervention. When I wrote Mr. President last week, 38-page letter with 3-page executive summary, begging genuflectingly Mr. President to kindly release Nnamdi Kanu in accordance with the July 20, 2022 decision ruling by the United Nations Working Group on Human Rights, where they say Nnamdi Kanu was extrajudicially rendered to Nigeria and that he was tortured, and that the federal government should release him immediately and also pay him compensation.
Chief Ozekeme, I believe that, you know, considering all that you said and seeing as the position of the federal government as well, this might be a matter that still will continue, you know, in the courts. But I think we should leave it there. We'd like to thank you, appreciate your time. I wish we had more time.
Tomorrow, it does not stop Nnamdi Kanu being released. The notice of appeal does not act as a stay of execution, nor does it render a judgment of the lower court invalid. They should release Nnamdi Kanu immediately and let him go. And let peace reign in Nigeria.
You can hear from the man, release Nnamdi Kanu and let him go. That is the problem with the Nigerian government. Very stubborn government. This particular government is very stubborn. They have no regards for human rights, no regards for the economy, no regards for anything. Everything they tell you is a lie. It's a big lie. Whatever the federal government tells you, it's a big lie. They just want to harass the people and keep the whole status quo. They want to keep the old status quo, telling people that things are going to change when they know that things are not going to change. The best and brightest of Nigerians now are leaving Nigeria. They're traveling abroad, seeking greener pastures. While the old heads are still holding down Nigeria in ransom, not making any viable change whatsoever to make things better. It's a victory against the government and against the system, against a system that has held people down for so long. So this is another warning to the Nigerian Attorney General. Don't behave like an outlaw. Comply with the appeal court's judgment. This government, this particular Attorney General, is seeking to behave like an outlaw. But he has to understand that he has to comply with the decision of the Nigerian courts. Because the Nigerian decision of this Nigerian court is the decision of Nigerians. Yes, because the court is a reflection of the Nigerian people. And the courts are expected to do what is fair and right for the Nigerian people. Oh, yes. So the Inter-Society, they have slammed the Attorney General of the Federation, Minister of Justice, has on how he interpreted the judgment of the Court of Appeal that has discharged the detained leader of IPOB. The appeal court justices, while ruling on Kanu's appeal on Thursday, declared as illegal and unlawful the extraordinary rendition of Kanu from Kenya. We've all known this in the past. It further held that the government breached all local and international laws in the forceful rendition of Kanu to Nigeria, all of it, thereby making the terrorism charges against him incompetent and unlawful. The Apex Court voided and set aside the charges by the federal government against Kanu and also discharged him. As you can see, this man is a free man. The Nigerian government is not telling the people the truth. They don't want to release him, but they have to, because it's the court that said it. It's not Michael Zekome that said it. It's not me that said it. It's the Court of Appeal. The court also held that the failure of the Nigeria to follow due process by way of extradition was fatal to the charges against Kanu. But the Malami, in a swift reaction to the judgment of the Court of Appeal, said that Kanu was only discharged by the court and not acquitted. So, as you can see, they have to obey the government of Nigeria, the court of Nigeria. They have to obey it. The government of Nigeria has to obey what it has signed up to. You cannot behave like an outlaw. You cannot behave like an outlaw. We have to behave like reasonable people that understand the value of human life, understand the value of society, understand the value of victory. It's okay to take your losses. Even as a human being, there's sometimes when you win some and you lose some. The federal government has lost this one. They have to take it, they have to take it hook, line, and sinker. They have lost this particular battle. This battle, they've lost it. They have lost this battle. It's okay to lose some battles. You have to learn from the battles that you lost. You cannot keep flogging a dead horse. Mazi Nnamdi has won the case against you. It's fine. Both citizens are allowed to win cases against the government. When citizens win cases against the government should not go and start crying and saying that they are going to file fresh charges just to prove another point. What other fresh charges do you want to file that you have not filed since 2015? You cannot take this court back to the High Court anymore. What other charges do you want to file again? So I am begging the Nigerian government to do what is right. I am pleading to them to do what is right, to do what is expected of them to do. This is even beyond what is right. This is what they are expected to do, to release and free Mazi Nnamdi so that he can go back and continue his journey. That is what I have to say. Whether or not they like it, it is not anybody's business. Whether or not they do not like it, what is concerns everyone now is that they release Mazi Nnamdi and let everybody go their separate ways. Nobody has to be a fan of Nigeria. Nobody needs to love Nigeria. If you don't love Nigeria, it is fine. If you love Nigeria, it is also fine.
There is a charge filed against Nnamdi Kanu, leader of the Indigenous People of Biafra (IPOB), delivering judgment on Thursday. A three-member panel of the Court of Appeal held that Kanu'S extradition from Kenya to Nigeria to stand trial was illegal. The court further held that the federal government failed to disclose where Nnamdi Kanu was arrested, despite the grave allegations against him. Kanu was rearraigned on an amended 15-count charge bordering on treasonable felony preferred against him by the federal government.
I will first meet my client, break the good news to him, then we discuss the way forward. Because the United Nations had already said Nnamdi Kanu should be paid compensation for the violation of his human rights, which this Court of Appeal again found today that his rights were brutally violated. The Court of Appeal was emphatic about that his rights were violated. Nnamdi Kanu was forcibly abducted, kidnapped, blindfolded, tortured, and then rendered back to Nigeria extrajudicially, extra-legally, against the laws of Kenya, against the laws of Nigeria, against all international instruments dealing with extradition, including various sections of the Extradition Act of Nigeria, including Section 15. They violated them. They brought Nnamdi Kanu to face a 4-count charge that was still pending, contrary and against what we call the doctrine of specialty, which is that when you bring back a fugitive through extradition process, you can only try him for that offense for which you are extraditing that fugitive, not earlier counts. And you cannot continue with an earlier case against that fugitive.
As you can hear, you cannot continue. The Nigerian government cannot continue wasting everyone's time. I have other things to do, better things to do than always worrying about what the Nigerian government is doing all the time. They have to do what is right so everyone else can go about their business and figure out what they want to do with their lives. Let me know what you think about that. Let me know what your comments are. Put your comments below. Let me see. What do you think is going to happen? But before I do, I want to play one final video from that has been handling this case, and that is Aloy Ejimakor.
And the can don't win. And he say trial court say he cannot try person where extradite, where go through legal process to bring back to Nigeria. Where you go by night, steal am like thief, come back, then he go say he go try am. Say that kind of thing no dey possible under Nigerian law and under international law. And na so I dey talk am since last year July. So today I dey happy say Court of Appeal don't validate am.
So what will be the next step for now? The judgment now, it means say Nnamdi Kanu go come up for DSS detention.
Man, So the judgment now, the process we say we'll go get the certified copy of the judgment, we go start the DSS, and then from there I ain't go home. Because the discharge and acquitted means say he no get case to answer again. So there won't be any trial. Remember last July, I granted an interview to BBC where I said that there is going to be trial within trial and that Nnamdi Kanu will not undergo any trial. I made that prediction far back as July 2021, and today I am vindicated.
What if government now won't go higher court?
Well, if they go on now, maybe now they are right. If they want go higher court, maybe Supreme Court. But we say the moment we go higher court, the thing where the lower court don't nullify. They're like that.
So the ball is in the federal government's court now. The Court of Appeal has done their own. Mazi Nnamdi Kanu's attorneys have done their own. Mazi Nnamdi Kanu has even done his own. He has been in their custody. So the federal government, over to you. Make a fool of yourself if you like. Do what is right if you like. Now you na sabi. At the end of the day, judgment is coming. Posterity will judge everyone who has played a role in all of this. I want to thank everyone who has been here today. Thank you for being a part of my show. Please kindly subscribe, follow The Leadership Standard on Facebook, YouTube, Instagram, as well as all social media platforms. I want to thank you all for listening. Do enjoy the rest of your weekend.